morning and happy Monday. Jackie Broman here from TBA Law. So I'm back again with my Monday mornings Facebook Live information. So I'll be doing this every Monday at 10 a.m. if you wanted to tune in. We do advertise what the topic will be on the weekend, so you can see what's coming up. And today I wanted to talk about appointing guardians for young children. So this is for parents who have children who are under 18 or for grandparents who have young children and you want to speak to your own children about appointing guardians for their kids. So the first little myth is that appointing godparents for your children is not a legal appointment. So it's a lovely thing to do, it's a lovely tradition, but the people you appoint as godparents are in name only. They're obviously someone special in your children's lives, but it's not a legal appointment. So if something happens to you, the godparents don't have any legal rights to look after your children or have any say whatsoever. So that's the first little myth. So the appointment of guardians needs to be made in the will of the parents for the children. It's particularly important for single parents as well. For single parents, if they don't appoint a guardian in their will, then the other parent of their child will automatically be the sole guardian. So if a single parent wants someone to step into their shoes in terms of the kids, they need to appoint a guardian. It's obviously also important for married couples or de facto couples who are still together, who are bringing up their children. If something happens to both parents and there's no guardians appointed, then it can be a little bit of a mess if both sides of the family don't get along. And this is one of the main reasons why I became so interested in this area, because I came across a case where a couple of young parents were killed in a hit and run accident, and then their children were in and out of family court for the following 18 months because the grandparents on each side of the family hated each other and they were fighting over who the kids lived with and didn't want the other side of the family to see them and wanted control of the money. So if you don't have valid wills setting out who are going to look after your kids, then it is very important. So a couple of mistakes then that parents make in thinking about appointing guardians for their kids. So firstly, people think that they should look to family first to be guardians. And yes, of course, family is often a great choice, but sometimes it isn't. If a parent of young children appoints their parents, being the grandparents of the child, understand as well that your own parents will be aging, okay? So it might not be the easiest thing for them to be doing to be looking after their grandkids if something happens to you. So that's the first thing to think about. Appointing friends is not that bad an idea. Sometimes friends might be better aligned in terms of your values than your parents or your siblings. So in terms of thinking about obligation, that's why we often go to our family first, because we think, well, blood is obligated to look after blood. But if it's not necessarily the best choice, then speak to friends about it, because often friends can be quite honoured that you would consider them to look after their children. And don't think of it as a financial obligation either, because what we can do is set up a trust around your kids so that funds can be used for the education of those kids, and the people you appoint as guardians won't have to dip into their own funds for the care of your children. So, firstly, the myths. Don't automatically think that a godparent is a legal appointment, because it's not. You need a guardian in your will for it to be effective. Secondly, don't always go to family first if they're not going to be the best person. So whilst you think that family is obligated, sometimes friends or an extended family might be the best choice. Other things to think about. Often name one primary guardian and then also have a backup. So if your first choice was one of your own parents, then name them. But again, have a backup in case your own parent is unable to continue being the guardian all the way through, have a backup there. Or the other thing is, don't name a couple, name the primary person in that couple. And then you might say, well, if that couple broke down, I don't want my kids to go through that breakup, so this is the alternate person. Or if that couple goes through a breakup themselves, this is the primary person who the kids are going to be looked after. So just think through those scenarios as well. You can also do exclusions of guardians. Now, we don't do that on the face of the will because it can be quite confronting. But if there's someone specifically that you want to make sure doesn't have any guardianship rights over your children and you think they might jump up and down if you passed away to try and get some rights, you can specifically do a document in the background saying the reasons why you don't want that person to have any guardianship responsibilities. Now, that would only be brought out in the event that the person you didn't want to be a guardian tried to do something. So no one would ever have to see those reasons and to make anyone upset. But in the event that that should happen, you've got your evidence there as to why you've excluded that person. So those are the main things to consider. Firstly, don't assume godparents are legally binding, because godparents unfortunately are not a legal guardian appointment. You need to do a will. Consider friends, not just family. So think about who would be the best people to raise your children and talk to them about it. Don't think that finances should be something that stops you from thinking about friends. This is the main reason why most people think family first, because of they feel like there's an obligation. But in terms of finances, we can set up things to make it nice and easy so that the person you appoint as guardian is not you dipping into their own funds for the care of your children. Think about primary guardian and a backup. Or if you're appointing a couple, think about which is the primary person in that couple that you're appointing. And the final thing that I want you to think about is exclusions of a guardian. So if there's someone that you're really worried will jump up and down and want to be involved in decisions about your children and you really don't want them to be, you can have a separate document that's not on the face of your will, that is only brought out if needed, so no one gets upset unnecessarily. But at least you've been able to have your say and put your evidence there in case that person does do something, if something happens to you. Okay, so not an easy topic to talk about. Parents of young children often don't want to think about what would happen to their kids if they're no longer around, but it is an important thing to think about, because if you don't do something about it while you can, then it's too late if something does happen to you. So thank you for tuning in, those who have. This video will, whilst it's live at the moment, will stay on the Facebook page, so if you wanted to share it with anyone else or watch it later, go ahead. I do these every Monday at 10 o'clock, a different little information session every time. If you did want to ask me something specific, then direct message me through Facebook, or you can jump on our website and all our email addresses are readily available there. So thank you.